Hi, welcome to the webinar and appreciate you joining us this afternoon, this morning, or whenever you might be catching up on this recording after the live webinar. I'm Margaret Wise. I'm Chief Revenue Officer with Active Prospect, and I'm joined today with Alex Krasovic and Aaron Weiss, and we're going to be talking about the recent McLaughlin ruling and some of the impacts that has on how we are thinking about the overall TCPA regulations, and what does that mean about who's in charge now and interpreting those regulations. So we're, I think some of us still barely off the roller coaster of thinking about one-to-one consent and a bit of the whiplash of what would that mean for us. And now we're kind of being thrown back into how all of this could be interpreted again. Is it at the federal level? Is it at the state level? And so we've invited some of our favorite experts to come in and join us and have a live roundtable about it today. So Alex, would you mind doing an introduction of yourself first?
Of course, Margaret, thank you so much for having me again. For those of you who may be joining for the first time, my name is Alex Krasovic. I'm a partner at Manat, Phillips & Phillips. I am a TCPA compliance and class action defense litigator. I have been doing TCPA work for over a decade exclusively. And, Aaron will beat me by this because he actually knows me from my youth. But I have seen the ups and downs of the FCC activity, of all the states and federal courts nationwide dealing with these issues. And I'm really excited to discuss one of the newer developments.
Fantastic. And I'm going to stop for just a second and ask our audience to start putting into chat a little bit about yourself, where you're from, and why you are interested in joining today. And while our audience is doing that, Aaron, will you give an introduction of yourself, please?
Sure. Thank you again, Margaret, for having me. It's my pleasure to be back talking with you folks and speaking on this topic with Alex, who as Alex indicated, I've been doing this a long time. And for when Alex was a baby lawyer, as they call him, and first started doing this, I got to work with her over the years. So I think I've been doing this, since 2009. So I've seen quite a lot of up and downs here, but I really do think that this decision that we're going to talk about, is kind of like, think of, Mount Vesuvius blowing up, and it's just going to just be a whole. We have to rethink whatever we've known for at least as long as I've been here, for 16 years doing this stuff.
Great. Well, again, you certainly helped understand why we invited you here today, and really appreciate you sharing all of your experience and insights and legal advice. I know when I talk about a lot of these topics, I feel like I introduce myself as, hi, I'm Margaret, I'm not a lawyer. So not providing official legal advice. And I know on this webinar is also not official legal advice, but definitely appreciate hearing your experience. So haven't seen a whole lot come through from the audience in chat. We've got Sherry, thanks for responding, who's a content writer and talking about some of these topics. Oh, great. Here we have a few more people introducing themselves. We have Scott is CEO of a multinational outbound agency. We've got Wendy is GC and SVP for a business services company. We've got legal compliance specialist, Kara, for auto advertising, Chad, marketing fintech. We've got Kelly, another counsel for marketing organizations. So Brad, thanks for joining. Amber, marketing. Looks like we've got a nice variety across the audience here, a lot of marketing and compliance and legal representation. So I'll read a few more off here just as they're coming in. Patrick with lead scores, Sherwin compliance, Jim, hi Jim from Citizens Disability, thanks for joining. Taylor Marketing, we've got DeBella, welcome DeBella. Love you guys, appreciate all of your support and partnership. Kevin Rockoff, hi Kevin, GC for lead marketing. Chris Siebert, hi Chris, VP Growth with Home Genius. Thanks for joining, glad to have you on. Wow, we've got a lot. Matt Tillman, hi Matt, glad you're joining. David Evans, we love you guys too. Thank you. David Jones, VP of Marketing, current home, long-term client, and Ruben's favorite. I had to throw that out there for Ruben. Thanks, he'll appreciate that shout out. So a few more coming in. So, oh, hi, Randy. Hola to you too. But we'll go ahead and jump in and get started, and I'll keep an eye on that as well. But definitely lots of interested attendees today. So thanks everyone for joining. To start off, Erin, I'll ask if you'll give us a little bit of background, kind of thinking about this ruling, and is this a rollback of the clock to 5 or 10 years ago? Or we have, as you heard, people that are new and know compliance really well. Some people are marketing, might be newer to the lead gen industry. Will you give us a little bit of summary and bring us up to date, please?
Sure. And I think that's a good way to look at it. Is a rollback? Is it, going forward, going backward? What is it? So here's what I would say. When Alex and I know we have some lawyers who may be on the call, there's a whole semester you could take a law school class called administrative law. And in even that one semester class, you probably don't learn everything about administrative law. But I'm going to give it to you in like 5 minutes. So basically, in a nutshell, in America, we have a lot of regulatory agencies. And communications, basically the big dedicated communications agency is the FCC, which was created in 1934, the Communications Act. And all these different regulatory agencies, promulgate rules, make declaratory rulings and the like. And there's different levels and different methods that courts have used to determine, whether whatever particular regulatory agency, and whether it's a rule, whether it's a declaratory ruling, something in between, how you interpret whether those are essentially binding on everybody else who has to kind of see what the regulatory agency is saying. Well, the FCC is one of about 6 agencies that had been kind of given a special kind of treatment. And that came from a statute that was enacted in 1950, which is known generally as the Hobbs Act, because the congressman who sponsored it was Hobbs. And under the Hobbs Act, which was enacted in 1950, the FCC and a few other agencies that are subject to the Hobbs Act, in a nutshell, basically whatever rule or ruling that agency would come up with after a proper notice of rulemaking would be a final rule, and there would be a very limited window, a 60-day period, to challenge that rule. So as Margaret indicated, those who are probably on this call, because I suspect if you're on this call, you're very familiar with the one-to-one rules that were all the rage. That's what all the kids were talking about in 2024. And we all know about the IMC challenge, I suspect, on this call. And that was the type of method where there was a challenge to the FCC rule. It was made within 60 days. It went to a particular court. The rule said it goes to one court. It went to one court. It happened to be the 11th Circuit. And that, the 11th Circuit struck down the one-to-one consent rule. But up until this McLaughlin case came out, 3 weeks ago, that was the only way that parties seeking to challenge one of these FCC rules, again, a plaintiff or defendant, kind of in our parlance, unless the challenge had been made within that 60-day period and the rule had been adjudicated and kind of vacated, then everybody was bound. I don't want to say stuck with, I'll say bound by that rule. And what that meant, and what people, you'll hear the term private enforcement action. What a private enforcement action is, it's a civil lawsuit. Very often a class action lawsuit where somebody sues as a class action, sues a company in a federal or state court, but usually a federal court, and says, I received so-and-so text message or phone call, or I guess fax. The McLaughlin case itself was a fax. And I think that my receipt of that call or text or fax violated a portion of the statute. That's what they call a private enforcement action. And until 3 weeks ago, basically every court of appeals that had looked at the issue said that those FCC rules were binding on the plaintiffs and on the defendant, and most importantly, on the trial court. So, you couldn't challenge what the FCC said about, whatever particular practice maybe 30 years ago. Some of these rules that are, provide a lot of the backbone of a lot of the, meat and potatoes of all our cases every day are rules that were part of the FCC's, original document implementing the TCPA from 1992. So 33 years ago. Some of them are more recent, like the text order talking about text messages counting under the do not call list. That came out 2 years ago. Or the portions of the revocation rules that weren't suspended for a year. Those became final 3 months ago. So some are 32 years old, some are 3 months old. And, there are even theoretically, there are new rulemakings that could produce. I know there are a lot of new rulemakings. The question, are they going to produce rules? That's an open question. But what the Supreme Court said 3 weeks ago, in a nutshell, is whatever the FCC said, a final rule. The McLaughlin case itself was a declaratory ruling, considered a declaratory ruling. So I have heard some debate about whether that applies to just declaratory rulings or final rules of the FCC. Maybe we'll talk about that. But in a nutshell, one way or another, there are going to be a portion of, and probably in my mind, a lot of what the FCC has ever said about the TCPA that was binding probably as of 3 weeks ago and now is no longer binding. So then the question, the short answer to the who's in charge is kind of this. The main answer on who's in charge is the trial court judge, federal court, obviously the district court judge. But ultimately, until in each particular, the way, the federal court system at least is set up is there are, in relevant part, 12 courts of appeal. And until each particular court of appeal issues a binding ruling, and there's a kind of a binding means that some court of appeal rulings are called binding, some are not binding. But until each court of appeals issues a binding ruling on any particular question under the statute, then in any given case, there's not going to be any binding authority on that issue. With the caveat, of course, the Supreme Court could, step in and issue decisions on certain things. But despite the fact that there seems to be a TCPA case at the Supreme Court every year, I can make one prediction, which I'm reliably comfortable stating, is that the U.S. Supreme Court is not going to be adjudicating every, I can probably sit here for an hour and think of 24 issues that kind of permeate TCPA cases. And that's probably probably would cover 95% of the action. The U.S. Supreme Court is not going to be, adjudicating each one of those big issues in the TCPA. Maybe they'll get another auto dialer case, who knows, but that's just not their role. So at best, the only, at least in the federal court system, the only final word will come for cases just making their way up the chain to the respective courts of appeal. And that's saying nothing about what happens in the state court system, which is a whole nother variable. So that's kind of the short of it. The who's in charge is, the district court judge who have lifetime tenure.
Thank you for that summary. One quick follow-up question to that. Does this open the door for any prior cases or judgments to be revisited, or is this only from 3 weeks ago forward?
So cases or judgments, what I would say is no, because there's a concept where we call kind of res judicata, meaning when you are a plaintiff or a defendant, and as the plaintiff, let's take the example of a plaintiff makes a claim, and let's say that summary judgment is entered against the plaintiff on so-and-so issue. Maybe it was prior express consent. And the plaintiff said, I don't think that the particular lead form conformed with prior express consent, and the court, grants summary judgment for the defendant. now the plaintiff said, well, because of whatever FCC rule being out, and this is just an example, don't quote me, like try to apply the example to a particular rule, that plaintiff would now come and say, well, hold on a second, now I have the chance to challenge that, so I want the case to be reopened. Well, that particular plaintiff had their day in court. They're out. But however, it could be a class action, and if you want as the defendant a motion to dismiss, remember, in a class action before class certification, your ruling is only good as to that particular plaintiff. So, there are theoretically some situations that have come up, maybe past conduct that a defendant may have got a favorable ruling and now may have an opportunity to take another chance. On the other hand, it's not going to happen where if a defendant lost on something, they're not going to proactively look for plaintiffs to sue them so they can, have the court say something new. So, but, that could come up for sure.
There's definitely some wrinkles to that too, Margaret, right? I mean, for people who are in active cases right now, this is an opportunity to revisit decisions in your case that have been made, motions for reconsideration, possible opportunity. Definitely things that we thought were settled law before, have a look, because a lot of those decisions are based upon FCC rulings and interpretations. And now there's a basis to challenge decisions that, may no longer be valid as binding authority, right? So I think there is a lot of play here. So while what Aaron said about res judicata is a fair point, I think, if your case is active, certainly there is plenty you could be doing with that. And even for cases that have recently resolved or that are in the appeals process, this is an opportunity for sure.
Absolutely.
It's a great lead into my next big challenge question, which is, do you think in this there are winners or losers in the context of lead sellers, lead buyers, maybe consumers who just want their rights protected, and then also consumers that are, one of my favorite terms, TCPA baiters. So as you kind of think across those groups, are we at a point yet to say who's coming out ahead or behind on this?
Yeah, there's, I've given this a little bit of thought because you did warn me you were going to ask this question. And I think this one's a bit of a tough one. I did the back of napkin math on it. And I think, from the compliance perspective, unfortunately for businesses, I think this might create additional boundaries or barriers for them until things really shake out in court, because there's this level of unpredictability now that wasn't previously there. So, there's that. If that could be considered, maybe you could be a potential loser. But depending upon how everything shakes out in courts, right, as Aaron said, these challenges are going to happen in district courts nationwide. Some of those decisions will be appealed. Those appellate decisions will be binding in those circuits, right? And then if there are splits of authority, it's possible, though, to Aaron's point, again, probably not going to happen in every circumstance, that the Supreme Court will weigh in at various junctures. And so what that will do is eventually, over time, create some settled law. And how those decisions fall could be favoring one side or another. Now, when you think about what are the issues that we might see challenges on, and some of them could be really, potentially significant. I haven't worked through, and I don't even know if Aaron's worked through all the possible challenges that you could make based on this, but there are some that come to mind right away. And so when you think about things that might end up getting challenged, we could probably see consent challenges. IMC left open this kind of idea about whether or not the consent regulations that the FCC has issued are really, let's just put it this way. The 11th Circuit didn't go as far as it maybe could have, but there was some language in there that people could use to try and undermine the prior express written consent requirements. And so, we might see some challenges there depending upon how that goes. Maybe that becomes, an issue that gets rolled back. If that happens, though, there's kind of a backstop, which is the statute itself says prior express consent is needed for certain calls, but what is prior express consent? There has been kind of an accepted understanding of what that means. That could be express. It could be like implied in quotes, right? And that is some of that based upon FCC ruling. So I think, we're going to see play there, but depending upon how that shakes out, we might find either things kind of stay status quo, in which case, I don't know who wins. Depends on your view of that. But if they get rolled back, maybe marketers have a win, for example, because they get a lesser standard of consent that they would be required to get. So I think there's just a lot to be seen, but there are potential winners and losers over time.
Great. When you think about the companies this is something we hear a lot, certainly our customers that are working with us, they are very responsible. They want to be good actors. They want to reach out to consumers responsibly. Does this change anything about what they should be doing? I know there's always varying levels of risk tolerance, right? That companies have to make decisions and balance the idea of what we do to generate revenue versus what we do to be careful of regulations and potential litigation. So I know we're early in this, but would you give any guidance on anything that they should be thinking about doing differently than they might be doing today?
Yeah, I mean, I would say anything that you are doing to be compliant. Again, I'm primarily at this point talking about TCPA and state law analogs. I know that probably covers, telemarketing sales rule as well, because I know we have a question about some CMS regs here. Mm-hmm. Remember, this change of McLaughlin doesn't affect anything that comes from the CMS side of the house. But with respect to TCPA, what I would say is this: whatever your compliance strategy was a month ago, because there are no Supreme Court decisions that have said that whatever, Alex gave the perfect example. I think there are terrific litigation arguments from the defense side that one can make on prior express written consent, which is, of course, not in the statute. On the other hand, the plaintiffs, I think, could make a good argument that prior express consent has to be something more than just providing your phone number. But again, these are all arguments that will happen in courts. And you will see at a lot of these webinars from other people and, different people posting on their, blogs and whatever, great arguments that people can make in court to defend these types of cases. If you take that and make that your compliance strategy, you are going to be courting trouble. So I don't think from a loosening the reins perspective, I would not suggest that anybody change what you're doing, because we just don't know enough how things are going to shake out. But there are a couple things that do give me some concern in certain verticals that, it's almost become the gospel in 30 years. The example I just gave for like in the debt collection space on using just the provision of a phone number as authority to call somebody. Now, the debt collection industry has gotten a lot better about actually getting a written consent. But if you're a debt collector, for instance, calling on just somebody providing a number and saying, well, the FCC said in 92 and then again in 2008 that that's sufficient, I don't know that will still work. So there may be things that you need to tighten the belt on, but I certainly would not loosen the reins. I don't know. Some of you may have already heard me say this at different, seminars, webinars, or whatever. The biggest risk, and I really truly mean this, for the the compliance professionals' nightmare is this: the worst place and the biggest site of disinformation on the TCPA and TCPA compliance is ChatGPT and other AI engines. And I truly mean this, because what these engines are doing, and particularly this has even come out, they're digesting the blog postings and client alerts that different defense side law firms have put in, talking about arguments that could be made in court, and interpreting those as stuff that could be part of a compliance plan, spitting out compliance plans that are taking kind of maybe aggressive arguments or novel arguments. Aggressive, not the right word. newer arguments that defense lawyers are going to be making, and telling people that this is the way you should comply. And people are spitting these chat GPT guidances out and implementing them as the compliance plan. And that's just, that's just, let me be unambiguous about it. If you're doing that, you're just courting disaster.
Well, ChatGPT is definitely not an attorney.
I like to prompt ChatGPT quite a bit and just see what I get out of it. And if you're using ChatGPT, then you've probably implemented one-to-one, because ChatGPT will tell you to do that.
Yeah, well, I think Erin's point is an excellent one, which is, one, now is not the time to be loosening what you're doing. And two, you may even need to tighten up what you're doing. And I think his prior express consent example is a really good one. If there ever was a time to revisit whether or not you should be getting someone's express agreement by adding language in your terms or including an additional disclosure under your phone number field, now is a good time to consider whether you should do that. I think that's always been, kind of a best practice, because otherwise you're leaving it up to a court to decide what's the scope of your consent, and you don't really have control over that. But, now this issue will be litigated. So the writing's on the wall that you may have your consent looked at, and, you want to be on the right side. So I want to raise another point with this, because we had an example not so long ago of what does it look like when the Supreme Court does something and then all the district courts are left to figure it out. For people with short memories, you still remember Facebook and everyone saying, this is the end of ATDS. Well, not so much. What you actually saw is district courts coming out all kinds of different ways and how they were applying the law. And there was kind of a spectrum of rulings that came out. And so for people who just kind of threw away their consents because they said, well, I'm not randomly or sequentially generating the phone numbers I'm dialing, some district courts did allow cases to proceed against, based on allegations of known phone numbers, right? So not every court is the Ninth Circuit on that issue. There's a lot of variant on how courts are interpreting that. And so you don't really have an ability to say at this juncture, how is it that every court is going to come out on this? And so I think that's an important thing to remember as you're making decisions from your compliance protocols. Are you going to be able to really hang your hat on what your decision is right now?
Great, thank you. I'm going to ask one of my last prepared questions, and while we're talking about that, I'll invite the audience to go ahead and send over any questions they have in Q&A, and we'll have a little bit of time to answer some questions there after this last final prepared question, which is flipping to think about responsible lead buyers and who are careful about the leads they're purchasing, careful about who they're calling. Are there things that they should be on the lookout for from the bad actors that might be trying to take advantage of this, that maybe ways that they should be aware that leads might be slipping through to them now? Should they be revisiting some of their vendor contracts? Should they be auditing their leads coming through? We always advise our customers to look at their trusted form certificates, and just having a certificate isn't enough. We say, go in and audit it and look at them, pull them forward and take a look at them. But are there things that you would say, do this? Could be just general best practice, or is there something that you might add to that to help them protect themselves against any additional cracks that this might open up for people that aren't being as responsible?
I have a feeling that the people who are on this call are sophisticated lead buyers. So this is probably like an unnecessary statement, but there will be people who are looking to take advantage of this and who will tell unwitting buyers, we don't need these things anymore. We don't need consent anymore. That FCC ruling that said, whatever it said is no longer binding. And, might try and convince you that you don't need to be doing certain things, or might push back on your requests for, certain standards, saying, well, that's not really required anymore. So I would say that's probably the biggest risk here. But if you are coming from a place of nothing has really changed, or maybe I need to tighten my compliance, then that kind of thing is just going to rule out those sellers to you. I don't know if Aaron has other thoughts on this.
No, I mean, and I've thought about this, for a lot of the different, verticals and for way people are acquiring phone numbers. I guess what I would say is there's, a lot of this stuff gets kind of complicated. So I've talked with some folks about what does everybody think of, warm transfers with an oral handoff. And, one would say, well, that, you may have a problem with that being written. And we know that there's aggressive interpretations from, we're not aggressive, arguments that different plaintiffs' lawyers will make on how the oral handoff could be a problem. And, you may wind up getting opinions saying, well, that comes, the written was written into the statute by the FCC. But what you have to keep in mind is, and this is where it gets so complicated, there's a difference on 227B where written gets, the FCC just added that, and 227C. Because in 227C, prior express written invitation of permission. Remember, 227C, those are the do not call category. That authority that the FCC had is delegated authority to basically go out and make whatever rules you think work. So that's where it gets very complicated because, everybody says TCPA and thinks of it as kind of one monolith of a statute, but it's going to become very important to understand for each particular type of regulation that's challenged, what's the source of authority for the FCC rule? And there's probably going to be a lot more, I think, deference. Probably the FCC regs and rules will have a wider berth for those that were promulgated pursuant to a specific granted deference. Now, obviously, within the granted deference, the FCC had to actually act within the deference. So the arguments people have made on the do not call claims, for instance, that residential calls, should those include calls to cell phones? And there are cases that say, no, the granted delegation was only for regulations covering residential numbers. And in 1991, that meant landline. So I think the short of it is, to get back to the question, is a long tangent, is we just don't know, right? There's somebody is going to figure out, whatever argument that people are, whatever good legitimate business practice I think that responsible lead buyers are using, somebody is going to figure out that edifice is, kind of, there's some FCC reg that was issued, in the 1995 or 1997 or whatever. There's a lot of FCC regs and, kind of exploit something. So I would just say, just continue to be diligent. A good written consent is always going to be the best medicine. And then a good written consent only gets you so far, because if you don't check against reassigned numbers, then you're going to have that exposure out there. So that's what I would say. Be diligent.
Thank you. One of the questions getting upvoted in our Q&A is, I know this is another recent development, is where does the Texas mini TCPA amendments fit into all of this?
Well, short of it is nowhere. I mean, that's so there's, in a nutshell, I mean, let's hypothetically say, you think there's some great argument, and now whatever consent problem you were afraid of or dealing with, you have a terrific argument, and within 6 months, every court of appeal is going to say, express written consent is not required for 227B claims, at least. Well, whatever that happens, Texas and every other state will still remain free to issue whatever regulations they want, aside from one case in 1995, there's these preemption arguments have never gone anywhere. So, that's the important point is everybody in this space has to continue to be diligent and see what's going on in any states they're, conducting marketing into. So, obviously where I'm in Florida, everybody here probably remembers the craziness that we had, particularly from 2021 to 2023. And then, I say even there continues to be issues because it kind of got, and I'll kind of use it as an example. When the Florida statute was amended in 2023 to cut the teeth out of a lot of the things that were causing a lot of the problems, there was all kinds of misinformation, Florida mini TCPA gutted, by the wayside, no concern. Well, there's still a lot of things there that continues to be a concern. So, and there are a lot of lawsuits on it. So if I don't think it would be a good idea to kind of say, all right, well, McLaughlin means that all this problems that I was worried about before, TCPA is going to be dead in the water. I don't think that's the case, but if somehow you think that, no, every time that any aspect of the TCPA has somebody said is dead, as Alex said, remember auto dialers 4 years ago, it's keeps on going. I mean, they used to make the joke when I first started practicing law, I was doing asbestos, which is this. This is about 20 years ago, and asbestos litigation had been going on for like 25 years. And the joke, it's a sick joke because asbestos is, people die from it. But the lawyers at the asbestos conferences, they would say, you know what the next asbestos is going to be like? The next big mass tort? Asbestos, because it's still going to go on and on and on. And it's still going on 20 years later. Every time I've ever heard somebody say, well, the TCPA is dead, I said, no, that's absolutely not the case. It's still going to go on and on and on and on. I was just speaking at the Florida Bar Conference on, something, and somebody said, well, are you still going to have a job doing all this stuff in 5 years? I said, yes, and I think that's a dumb question.
So suffice it to say, not sure yet, and don't change what you're doing, and not ready to pick a state to follow yet.
Well, I think that there's an aspect of this that is worth emphasizing, which is your compliance program really needs to have two parts. It has to address the TCPA, and then it needs to address state law. Now, sometimes what you're doing will take you out of the purview of state laws, or most of them, because, the TCPA right now has still stringent requirements. But if you ever are in a position of finding that the TCPA does not apply to what you're doing, you better be asking the second question, which is, okay, is the rule the same in the states? Because, there are lots of things that are different in states. Examples would be exemptions, right? You think you don't have to scrub the National Do Not Call Registry. Well, if you're relying on an exemption, you better be sure that the state exemptions match, because some states have their own state requirements for national do not call scrubbing or state do not call scrubbing. And those exemptions may be different. So there should always be a second part to that question. And I think with regard to Texas, what we're going to see, and we already were seeing, a lot of litigation with Texas claims in it. And I just think it's going to increase the number of Texas cases that we see.
Thank you. I want to hit on a couple of other questions here, although that covered a lot, and thanks for the detailed answers. One, and Aaron, I think you hit this one earlier, but just to confirm, there was the question about if this impacts current CMS 1-to-1 and the 48-hour rule. I think you said this doesn't change anything for CMS.
Yeah, that's what I would say. This is CMS is governed by it's a different regulatory agency, so whatever the HHS, that's a tongue twister, regs are, that was not a regulatory agency covered by the Hobbs Act. So that's still on there. And if somebody wants to challenge the CMS regs under like the Loper-Bright regime, this is a different kind of standard. that's a challenge that, somebody theoretically can make, but that's not, going to be directly affected by McLaughlin.
Great. We've got a lot of other great questions coming in here, and one hits on AI. So I wanted to bring this one forward, which is, this was an interesting one. Gathering consent on an ad for an automated AI call that sets an appointment. Is that a risky strategy?
So I feel like I'd have to know a lot more facts about this to opine. But what I will say are a few things. One is AI, I guess that's one of the theoretical open questions about the TCPA. Although I think you would hear a lot of people say, certainly from a compliance perspective, you better be prepared that could be classified as an artificial or pre-recorded voice. So you probably have consent requirements under the TCPA. This case, an appointment. So, depending upon what your appointment is about, maybe it's not marketing or maybe it is. I think you need to be thinking of a call like this as kind of your run-of-the-mill automated calling restriction. If you are in an AI case, then don't take it that I'm not saying don't challenge the AI issue. I go right ahead and do that. But I think if you're doing it from a compliance perspective, you need to be prepared that the courts are going to align with what the FCC had issued on its interpretive ruling for that issue.
That's great. There's a few AI questions that we've had come in. I think this one is a follow-up to that, which is there any reason to treat AI voice bots differently from pre-recorded voice? And if so, what would you do differently for an AI voice?
Yeah, I mean, I would probably, like Alex, want to know a little bit more of the specifics, but I think, directionally, what I would say about AI is, the FCC issued the AI, thing. Was it 24, I think, although it may have been 23, but don't quote me on that. I don't even know that they had to. I mean, artificial voices are in the statute, 1991. So, I mean, I don't know. I mean, I'm usually a kind of a purist for what's in the statute, and they said artificial in the statute, and I always thought that AI means artificial intelligence. So, I mean,
there's one question on it in terms of the outbound, and I think that's probably a fair interpretation. If you're using it, that's artificial. What about using it? We have another question here. What about using it to get consent? I mean, is there anything to consider in that? If, AI can solicit written consent, is there anything to be concerned about in that?
You mean like an inbound process? I mean, because I think that's the question, right? It's like, are you using the AI for your outbound call? If you are, then you need to be asking questions like, is it an ATDS or is it an artificial or pre-recorded voice? If you are collecting the consent on the inbound, then the things you should be thinking about really probably are more like, is the consent that we're collecting valid? Is it going to be reliable based upon the way the AI is operating? And am I going to get the things I need, the elements that I need to satisfy those requirements? For AI, I also want to put an asterisk. While it's true that it probably will be artificial or pre-recorded voice, there are arguments based upon statutory interpretation about the definition of artificial and artificial voice, and also what that meant in 1991. So if you have a case and you want to talk to me about those arguments, I'm happy to discuss them with you. We have made them for clients already. But certainly from a compliance perspective, you need to be approaching it as if it will be classified that way.
Yeah, no, agree 100%. Just compliance and litigation, you have to wear two different hats with those.
Got it. And there's a question here. I'm not 100% sure of this one, but maybe it'll mean something to you guys for sure. But how did the changes affect patient statement SMS delivery? So I'm thinking that's healthcare related and sending that. So
the biggest one,
text or consent. I don't think anything's changed in how texts are viewed.
That's right, Margaret. But I think maybe what we could say is that question about prior express consent that we were discussing earlier, which is, is the consent you have to make that text message, is it adequate? If you're relying upon a phone number provided to someone else in that patient relationship, perhaps a health plan and you're the provider, you should be asking questions. You already should be, but you definitely at this point should expect that the prior express consent issue could arise. So like, is your consent scope enough to cover what you're doing? As the sender, are you the person to whom that person anticipated their consent was being given? So those are the issues that I think still exist for that. I don't think it really changes it. It just probably makes it more likely to be litigated.
Got it. I've got one more, and then I'll ask our closing question to you guys. And the one I'll ask before that is, I think this is a really interesting question, is there a good place to track the litigation or the litigator's recent activity? So if we're having a good conversation, we're talking about, hey, there's going to be a lot to be watched. Is there a good place to watch for that?
I don't know if Erin wants to answer this one. I will say you can lean quite heavily on your TCPA counsel. We are keeping an eye on the developments. We are watching for trends. We will be able to tell you this information. I know a lot of us probably send alerts out to our clients about, important developments. Certainly if any of this percolates up into binding decisions, or we're seeing, a big sweep, we would probably say something about that. But, I do think that if you're asking questions like that, have a conversation with your outside counsel. And then there's lots of resources online, and not ChatGPT, but from reputable TCPA firms. And you can follow those developments as well.
Yeah, I would agree with that. There's a lot of information out there. It's, whether it's all collected in one source, that's probably a different conversation, but there is a lot of information out there.
Well, and I'll also invite everyone to follow along Active Prospect. We try to bring a lot of these issues to the front and bring a lot of attention to it and expert voices to it as well. So if you are looking for counsel, we have a couple of great options here today, as well as a lot of prior webinars to chat as well. So that'll kind of lead me into my last question that I think is an interesting one. Also, I think that there's a sense that the changes from the originally planned one-to-one consent regulations were changed, and that was a correlation to a change in our administration. Should we continue to expect some of these maybe dramatic swings as our final question from the audience today to wrap up on?
I think we can expect a lot less regulatory activity. There's obviously been directives to these agencies, including the FCC, to not issue new regulations unless they eliminate 10 others. And we know the FCC has delete proceedings underway. So you should be keeping an eye on that. It's only really just beginning, whatever they're going to be doing. I actually anticipate more deregulation, and maybe, the enforcement side of things really is going to depend on what the pet projects are, because there is still some enforcement activity taking place, but it's, as with any change in administration, it depends on what the interests are, and whether or not our particular world here is going to be impacted is an open question. But I will note that while we don't have many bipartisan issues that everyone agrees on, I think there is a lot of bipartisan support for, kind of an anti-phone call world. So I don't expect a lot to change in that regard. I don't know if Erin has other thoughts.
Yeah, I'll take them kind of in reverse order. I forgot who it was, but it was a congressman from Nebraska who only served a couple terms, but somebody probably got his attention, and he was the one who tried to carry a bill to get rid of the TCPA about 10 years ago. And the bipartisan response and just breaking that guy over the coals was, quick and effective. So I don't know that anybody wants to be the one. People distill things to 10 words, or I guess 140 or maybe 200 characters on what you could put on X. So I don't think somebody wants to be the congressman that's going to be pro robocalls, because that's what they'll say on X. In terms of the regulatory action in the next couple of years, I think it's just across the board. We've seen a lot of executive orders. I don't think that we're going to have executive orders directed towards outbound calling and texting, but who knows? And I just, across the board on the regulatory agencies, I think that's where a lot of the action is going to be. And there's a real, encouragement for the regulatory agencies not to be issuing new regulations. And I think on enforcement, look, I think my take on it, and others may have other thoughts, but on TCPA, I think you'll continue to see, particularly states use TCPA as a claim, as kind of what I call an accessory claim to some conduct that, if objectively my grandmothers would have looked at this conduct, some scheme, the snake oil salesman, the TCPA has always been a useful tool to state regulators for coming after the snake oil salesman, because the person selling snake oil, whatever the state reg may be, they may not be able to get actual, more than actual damages or whatever. But the TCPA has, always given the state regulators a really big sword. So they like it for that. It's not so much that the state regulators are using it to target, people for making phone calls or text messages, and that, they may be doing something very legitimate and selling a product that everybody understands there's nothing wrong with, but they happen to be doing it by selling by text messages or phone calls. So I think you'll still see a lot of that. That's not always been the biggest thing for the feds, although sometimes, you've seen those. I mean, an FTC, of course, when it's a federal regulatory, can use that as well. So, we'll see. And I guess that is an interesting question I've thought about. The FTC is not covered by the Hobbs Act. So whatever the FTC does on an enforcement side, their regs are on a different plane. So that's something to think about as well. And same for CMS.
Well, thank you guys very much. I think the high-level summary takeaways are, it's a little bit early to tell for sure. Continue to be safe. Make sure you have trust and control over leads you're acquiring. Make sure you've got control over the consent and you've got record keeping of that consent. Continuing those best practices. And I think always staying on the right side of it in terms of responsible reaching out to consumers that are expecting to be reached out to for the reason that you are reaching out. And I think if you stay within those guardrails, it sounds like stay the path, stay responsible, and in the long run, probably be okay. So thank you guys very much for joining us today. Appreciate the time. Thanks to our audience. We'll post a recording of this, and we'll have a blog recap as well, and try to hit any answers that we didn't quite get to in the Q&A. We'll try to make sure we include that as well. So thanks everyone for joining today.